Okay. Okay, now I see it better. Okay. I do have a presentation, so I can share that whenever you like.
Yes, I have you on Spotlight, so we should be good to go.
Okay. So do you want me to just go ahead and share my screen? Okay,
Absolutely.
great.
And you could also
Okay,
maybe introduce yourself,
sure.
the law firm and the services offered, and then we could jump right in.
Okay. Hopefully this will work. Not used to using, okay, it looks like it's working. So I don't know if there's anything
Yes,
else I should do, but I'm just going to go ahead
it's
and
good.
show what I have.
Yeah.
Okay.
Mhm.
Okay. Well, thank you so much for the opportunity to speak with your organization. So I am Ann Badmus. I am an attorney. I have been practicing immigration law for many years, over 30 years. And my primary focus has been to help our clients with applications or processes related to employment related immigration. So that's where, if you were hired or even if you're self-employed, which we'll talk about today, we help with getting the necessary visas in order to fulfill your work goals, your business goals, that kind of thing. So we have been, as I mentioned, practicing many, many years, have helped thousands of clients. We are located in Dallas, not far from UTD, off of 635 and 75. But we work with clients all over the country and pretty much all over the world as well. So again, thanks for the opportunity. I did provide a short presentation to kind of get some information to the audience in terms of some of the options related to for employment and self-employment for F1 students. And I know there's a lot of questions, so I'm going to leave enough time for that as well. Okay. So, like I said, we're wanted to, first of all, before, as a lawyer, we always have to let our audience know that when we're providing these types of presentations, it is for information only. Please do not consider this legal advice because there's so many differences, so many different factors that go into any visa application. So this is just really very general information to just kind of give you some knowledge and then go to the next step of getting very specific advice related to your situation. So again, please don't consider this legal advice, but do consider it information that you could use as a step forward. So today I wanted to kind of go over from my understanding of what you were looking for is some information about options for working or starting up a business and being able to, to in the U.S. Operate and run a business. So we're going to talk about this different visa options or statuses. Of course, we're going to talk about OPT a little bit, STEM OPT, and then some visas that typically have been used for people who to either work or to work for themselves as well. Let me see if I go forward here. So the first one we want to talk about, of course, is OPT. So most of you probably do know that once you are in your completing your studies, most F1 students have the opportunity to get OPT, which is optional practical training, which allows you to gain some practical experience in your field of study. And usually the initial OPT that you receive once you work with your international student advisor and get the paperwork done. Usually you get up to 12 months of work authorization to work in your field of study. So that's very important. So because the work that you're doing, whether you're doing it as self-employed or working for someone else, has to be related to your field of study. So this is an option to be self-employed because it is allowed for an F1 OPT student to actually be self-employed. So if you have a startup company that you're starting up, you can do that with an F1 OPT. There are some restrictions to that, of course, because it is limited to that 12-month period. So you're really going to be limited to just that 12 months and then having to look at other options to extend your ability to work from there. Sorry about that. I'm not sure why that's going on. So um, the pros about that is that there's no real money amount that's required. You have flexibility in the types of ways that you set up your company. However, again, the work that you're going to be doing in that company has to be related to your field of study. And you, of course, have to provide the information that's needed as part of your compliance with the OPT and making sure SEVIS is updated with what you are doing as far as work is concerned, because there are requirements that you have no more than 90 days of unemployment during your OPT period. So sometimes this is really a good option for those who haven't been able to find a job and do want to at least, not run into that issue of not being employed within the 90-day requirement. So being self-employed or being a contractor doesn't necessarily have to be a startup, but you can be employed by a company as an independent contractor as opposed to an employee. So those are kind of legal terms in terms of what's considered an employee and what's considered an independent contractor. But again, this is possible for you to be called self-employed on an OPT. However, as I mentioned, you have to think about what's next after that. So many of you, especially in technology, would be eligible for the STEM OPT extension, which gives you another 2 years, 24 months or 2 years to continue working. So you would have a total of 3 years of OPT eligibility. However, it is not really possible to be self-employed under the STEM OPT. And why is that? It's because STEM OPT has certain requirements that are different from the OPT, initial OPT requirements. So primarily, someone in STEM OPT, their employer must be an E-verified registered employer. And there must be a really very formal employer-employee relationship where there's a training plan, there's a lot of um, uh, compliance requirements that has to be given to the government to show that you are indeed being trained during this 2-year period. So unlike OPT, the initial OPT where you don't have a training plan, you just have to update that you are working. With STEM OPT, there are a lot more restrictions on what you can and cannot do, and what you have to, and what the employer has to do. So being self-employed in that circumstance is probably not going to work because you're not going to be able to say that the company is training you to do the work in your field of study. So this really isn't an option for most. It really isn't an option. We don't recommend to try to do self-employment on STEM OPT. However, as you all probably do know, there are other options as far as getting a work visa, and most of you know typically the usual work visa for most college graduates, especially when F1 status, would be H-1B visa. So the H-1B visa is for professional workers. So you have to show that you are in a specialty occupation, meaning that the field of study that you're in has specific requirements. It's not just a general degree. For example, general studies typically would not be considered a specialty occupation, but if you're in technology, any of the STEM fields, usually that's going to be considered to be a specialty occupation, but you have to show that you are going to work for a company or even self-employed, as I'll talk about in a minute, with in your field of specialty. So if you're in a technology field, let's say if you're a software engineer, for example, then you need to show that you're actually going to be working as a software engineer using the knowledge that you gained during your studies. So the H-1B visa does allow for entrepreneurship. And what I mean by that is that although usually you are required to have a U.S. employer to apply for your H-1B, you can, as an individual person, set up your own company structure, such as an LLC or a corporation. That has to be some distinct company structure. It cannot be you personally as I'm just going to be independent contractor, self-employed. You actually have to set up a company that has its own tax ID number, has its own identity, and that company will now be your sponsor for employment. So if you're able to do that, which in most cases, most states don't have any issue with anyone legally setting up a company and being the primary or 100% owner or a partial majority stake in the company. But if you do set it up correctly, then you can apply for that H-1B in order to work for your company in your field of expertise. Recently, this year, in fact, the government specifically stated the rule. We've been doing this for many years, but this year the government formalized that process where it said that if you do qualify as an H-1B entrepreneur, then we can give you an H-1B to work in your company, whether it's a startup or an established company, and you can work in that company primarily in your field of expertise, but you can also have duties that are for management of that company as well. And if approved, you would initially get 18 months to work in that company. You can then renew for another 18 months, and then after that, if you're still wanting to be employed with that company, you can extend for 3 years as well. So you can get the full 6 years of time on H-1B through your own employment. So that is a major help for many people who are able to do that, whether they partially own or 100% own a startup company or any established company. But there are some cons to that, mainly the H-1B limitation, the H-1B cap, where there's only a certain number, only 85,000 H-1B visas available, new H-1B visas available each year. So it's a very competitive process where through the H-1B lottery system, where usually you have at least 400,000 applicants for those visas, you have to be lucky enough in order to get one. So if you were going to go that route, you would first set up your company, have your company apply into the lottery. And if you're lucky to win, then you'd be able to apply for the H-1B visa. But of course, if you don't win one of those slots or visas, then you would not be able to go forward unless you can somehow get your company to be considered to be cap exempt and have some other workarounds there where you're in a cap exempt situation. We don't have really a lot of time to talk about that, and that might be a question I can answer later, but that would be another way of trying to be able to have an H-1B despite the fact that you did not win in the lottery. So the next two, because I do want to give some time again for questions, the next option that you could look at would be an O1 visa. And this visa is more focused on your individual accomplishments. And there may not be, there are many, I mean, we have worked with some students that have qualified for this, but I won't say that it would, every student can qualify for this because it really depends on your individual background. But the O1 visa is an option for self-employment. You can be self-employed. So like the H-1B, if you set up an LLC or a corporation and have that corporation apply for your O1, then it is possible for you to work with an O1. The advantage of the O1 is that there is no cap. There's no lottery. It's unlimited O1s available for anyone who qualifies. You can have indefinite extensions on the O1. There's not any limit on how long you can have an O1. But it does require that you prove that you qualify. So that qualification really is focused on what your background is. And so the O1 visa usually has about, depending on your field of expertise, has about 8 to 10 criteria. And you have to prove at least that you meet 3 out of the 10. So some of the types of criteria they have are things like, have you won awards, national or international awards for the work that you've done? Have you written articles, scholarly articles, or even business articles or articles that have been published for the general public or for people, not general public, for people in your field of expertise. So for example, if you are in technology and if you've written papers that have been published in IEEE or some other professional organization that has, been willing to publish your work, then you could potentially meet that criteria. If you've been asked to be a judge, perhaps in some technology contest, or you've been judging other people in the field of technology, judging their work in some way, even in teaching, for example, that could be a possibility. There are other types of criteria as well. We don't have a lot of time to go through those, and we can talk about them later if you have questions. But I put here a link to the website where you can find the very specific criteria. So if you can prove that you are of O1 caliber, and you have your own company, a startup company, then you can get an O1, and that would allow you to work for yourself pretty much. And lastly, I wanted to talk about the E2 treaty investor visa. Now, this is uh, definitely self-employment eligible because it is all about someone starting a company, someone starting or buying a company in the United States where they are going to actually operate and run that company. So it is, so definitely this would be something that it could be viable for a startup or an existing business or purchasing an existing business. But it does have, it is limited in certain ways. In particular, you have to be a national of the countries that are eligible. There's about 50 countries that are eligible for an E2 visa, and I have the link here where you can see the countries that are eligible for that. So if you are a citizen of those countries, any of those countries, then you could apply for the E2 visa. Most of the countries are places like, well, most of the countries, like, for example, countries that are very large generally are not part of this treaty. So, for example, India and China, those, if you're nationals of those countries or citizens of those countries, you would not be eligible for an E2 visa. But if you have a different citizenship, for example, some European citizenship or Canada, even Mexico. Like I said, there's 50 countries there. Some of them you'd be surprised that are on that list. But if you are a citizen of any of those countries, then you can apply for an E2 visa. But the main requirement there is to show that you have made a significant financial investment in either starting up or buying a business. Now, there's not a specific dollar amount that the government says you have to invest. What they do say is that you have to show that for the business that you are starting up, you have made enough investment to give it a good start. So, for example, if typically a business that you're starting up usually might if it takes $50,000 to start up, then you would show that you've put in that $50,000. If it takes $100,000 to start up, then you have to show that you are investing that 100,000. And the investment can consist of different things. It can consist of your own finances, like if you have the money that you've saved up and you're able to invest, or if someone has gifted it to you, or someone has lent the money to you. There are different ways that you can show that you're making a legitimate investment into that. So that's kind of the end of the different types of visas that you might consider. So I'm open now for any questions if anyone has any.
Thank you, Anne. We'll open the floor. If anyone has any questions, please just raise your hand and we'll go through that. Otherwise, I prepared a set of questions just in case people got tongue-tied. All right, so no one's taking the first step. So why don't we look at this now? So in terms of the timeline you can expect, and also the nature of the company itself, like, sorry, Wasil will start with you. I'll come back to my question later.
Are you sure?
Okay.
Sure. Hi. Good presentation. Definitely answered a lot of the questions I had prior. I was curious though, I noticed how essentially if you have your own LLC or your startup, you can prove legitimacy and self-sponsorship, whether you're on the H-1B or the O-1 or even further than that. But I noticed that let's say you started during your initial OPT. What happens when you're on your STEM OPT? Are you unable to like continue with the business if you extend on the STEM OPT? Because I noticed that there is no self-employment eligibility.
Exactly. Yeah, that's correct. Because yes, so you would be very limited unless you can figure a way where you can have others involved, for example, that are also owners in your business that could provide the training. Because the reason why the STEM OPT doesn't work typically for self-employment is because you have to have that training plan. It's not about you running the business, it's about you getting that specific training in your field of expertise for that 2-year period. So those training plans are that form a 983, an employer has to complete that and provide details along that 2-year period. Like, for example, every quarter, what are you going to be learning? How are you going? Who's going to be supervising you? There's a lot of questions there that have to be answered. So if you're just alone yourself in the company, that's not going to work. Mhm.
I see. I see. Just a quick follow-up. So let's say hypothetically, the company I would be involved in would have maybe it would be a partnership with, I guess, someone who's a citizen. So and let's say the company would be able to whip out a training plan to prove that I'm on my STEM OPT. Would that be possible?
Yes, so that would be possible because yes, if you're a partial owner as opposed to 100% owner, then it's going to be possible in that sense, where you do have, as you mentioned, someone who can provide the training plan and indeed provide some of that training. That isn't really a question in terms of, okay, how much do you own or anything like that as far
Mhm.
as that process is concerned. But yes, you want to make sure you're complying with the STEM OPT requirements by having that training plan in place.
I got it. So the key being the training plan. Thank you.
Mhm. Sure.
Just to kind of highlight, and you can tell me if I'm wrong here, your co-owner still has to be someone who's qualified to supervise and give you training. It couldn't just be one of your classmates who's a
Correct.
citizen who's a, yeah.
Yes,
All right.
exactly.
The next question is from Robin.
Hi, and great presentation. Thank you so much.
Thank you.
Uh, so you mentioned that while teaching, if you're judging, that qualifies as one of the criterias for O1. So I had a question for my friend here.
Mhm.
So he was a teaching assistant and he was also assigned to judge the final projects of the class he was teaching assistant for. So does that qualify as one of the criteria?
Technically, it could. Um, I will say, I mean, they have varying degrees of, so the O1 is very subjective in
Mhm.
terms of the evaluation of the application. So you may have one person with what you think is identical as far as qualifications, and one gets approved and one doesn't because the officer, whoever's looking at it may not feel the same way.
Mhm.
So and they do have, some subjectivity provided within that whole criteria. So when we talk about judge of the work of others, which is the criteria that I mentioned, where we're looking at teaching. So teaching is considered to be judge of the work of others. However, if that's the only thing that you're doing, they may not give it as much weight because they can still say, yes, you meet the criteria, but we still don't think you've reached the level of international or international recognition.
Mhm.
Now, if you had done something external from your job, for example, like if you were doing peer review on a journal, for example, where you're not employed by that journal, but have been asked to review other people's presentations or papers or things like that, or even at a conference, like you've been judging a best paper or something at a conference, those types of things. That's going to have more weight than if it's part of your job to be judging people's work.
Got it. Thank you so much.
Mhm. Sure.
And who applies the O1 for you? Is it the company that you're working for, or you can apply for yourself?
So it would be a company. So if you wanted to work within your own company as an owner of the company, then that can be done as well. So we work with a lot of people that we've done O1 where they've just formed their own company. Usually they're even 100% owner, and with forming an LLC or a corporation, you get your tax ID number for the company as well, and you do have to operate the company like you would any other company, but that company would be your sponsor. So the application would show, Robin's company as the sponsor for you as the beneficiary, or the person getting the visa.
Got it, and thank you so much.
Mhm.
Yeah, one thing maybe the audience could just keep in mind is in legal terms, a company is treated like a person, like an independent entity. So that's why it has to be distinguished that your company is sponsoring you, even if
Correct.
it's technically you working through the company.
Correct.
The next question is from Vishal.
Hey, yeah, really informative session. Really thankful for that. It's really informative, helping us keep on top of things. Just one small question. Suppose we do establish our LLC on STEM OPT after our graduation is done. And after starting our firm, we have, let's say, hired 10 employees now. We don't have a mentor who can give training to us, but we, as the owner of the LLC, are providing training to the 10 new employees we've hired. So, in this case, does that count as mentorship? And would that be recognized as a firm? And can I file for an H1B in that case or not?
Well, that's two different things. So as far as STEM OPT, if you are the person on STEM OPT, then you have to be one being mentored, not providing mentorship. Okay. So that would not help if you were the one who was mentoring other students, even though I'm sure you're fully qualified to do that, but the program requires that you have supervision and training that's going on within that company. Now for H-1B, that's not a requirement. So if you're able to, get into the lottery and win one of the H-1B visas, your startup company is able to do that, then it doesn't, there's no issue related to whether or not there's any training going on for you.
That answers my question. Thank you so much, Anne.
You're welcome.
All right. So going back to the question I had before, given that it's roughly a month since graduation happened at UTD, and assuming most of this audience is on the OPT 90-day ticking clock right now, what could be a realistic timeline for them to start a company, even if they're vibe coding it and it's an app they made today, to filing for that OPT and just stopping that clock while they're working on this and maybe even looking for employment outside?
Sure. So assuming you're saying assuming they already have OPT and have applied for it, right?
Right. It's in the
Right.
like they graduated, they've
Yeah.
applied for the OPT, but they're still not with the job in hand.
Not the job in hand, right? So as far as starting up a company or forming a company, so that typically, at least in Texas, it usually probably takes a few weeks at the most to do that. What you have to have, of course, is a company name or names that you want to use. You have to identify in the paperwork that when you're applying for either an LLC or a corporation, who are going to be members or owners of the organization. You have to pay the fee that's required to the state, and it's electronic, so it does not take a long time. The state itself can probably issue your company, assuming that there's no conflict with the name that you've chosen against any other company in the state. They can usually issue the state formation documents within a couple of days or so. And then you also, at that time, once you get that, need to apply for your tax ID number from the federal government, the IRS, and that usually takes, actually can be done online as well. It usually takes a day, well, a couple of hours really, that can be done. So it can be done pretty quickly as far as starting up or forming that company. And then just having a company itself, of course, doesn't mean it's operational, because there's a lot of companies that what we call shelf companies. They've been formed, but there's really no business going on with them. So you can keep that as a shelf, but if you decide, hey, I want to go ahead and start running the company, how do you start running the company? You start to actually, well, you can operate out of your home if you like, but find a place of operations, start marketing, start development, as Vijay mentioned, or Santosh mentioned. You can start doing all those things that would actually be running a company. But of course, you want to keep in mind that what you're doing still has to relate to, if you want to use that for OPT purposes, relate to what your field of study is. So somehow you're going to have to create your job description and start doing responsibilities that could be, would be related to your field of expertise.
Right. Thank you. In terms of other questions, it is possible, based on that slide you had on entrepreneurship H-1B, to have a different employment, work for that employer, but also kind of part-time work on your startup, that you can have two H-1Bs kind of, or split that H-1B across the 40 hours to still work on your startup or switch over, right?
That's correct. So you could have multiple H-1B employment. So you could have, and any H-1B can be part-time or full-time. Some people can have two part-time, or they can have one full-time and one part-time. There's not any requirement that any one H-1B be full-time. So you can apply for a part-time H-1B and have multiple part-time H-1Bs. But if you are wanting to, operate or run your own company while being employed with another company, then you definitely would need to make sure that you have applied for the H-1B and received that H-1B. And you have to keep in mind, again, H-1B, the occupation has to be related to your field of expertise. So sometimes we get questions like, oh, somebody wants to, invest in and be part of the operations of a restaurant, but they're not, that's not their field of expertise. That's not going to work for H-1B purposes. So it has to be within your field.
Right. There was one point mentioned in the chat that simple mentorship or judgment by itself, even if it's paid, is not considered valid for O1 eligibility. Like, you cannot be paid to go judge. Is that something you've heard of, or you could give some insight on?
Paid to go judge?
Maybe Tushal, if you want to elaborate.
Maybe elaborate a little more on that.
Sure. Yeah. Hi, Anne.
Hi.
So my question was very simple. There was another law firm called Saints Alliance or something like that. They also came to UTD, and they did something very similar. And so somebody asked this question that, can I be a part-time teacher at UTD? And, because of that, I'm technically a mentor to all these different students. And so would that be considered, as like judging or mentorship or anything of that aspect? And so I think what they said was, since you're being paid to do that particular job, it's part of your job responsibilities. And so that would not be considered valid by USCIS. And so it's only if you were invited as a speaker, let's say at a big conference, or if you were invited by UTD to come be a panelist, only then, it's like somebody's seeking out like your intelligence and your wisdom to come and be part of this event. And so only in that context would it be valid. So is that like the right advice, or do you see it more of a gray area?
It's kind of similar to what the other question was. So the fact to me, it's not the issue of being paid as part of your job. It can still be considered, and there was a very specific case related to EB-1A, which is very similar in criteria, but it's for the green card many years ago, where the question was, whether someone who was a professor or a teacher and they were involved in judging, for example, a PhD dissertation or judging other, students' work. And the government said, or the court said, yes, that's still considered to be judge of the work of others, but how much weight that's given overall, once they look at the whole application, it may not be strong enough, because when an O1 or even an EB-1 application is evaluated, yes, they look at each specific criteria and they say, oh, yes, you meet this one, you don't meet this one, or whatever. But then the officer has to feel that you have met the level to them where you have this national recognition as one of the top people in your field, because it's a very high standard, right? It's either, if you have a Nobel Prize, no problem, that's going to meet the criteria. But if you don't have that, then you have to show other things like these different criteria we're talking about. So just, if the only thing you've done as far as judging the work of others is through your teaching, which is perfectly valid. And they'll say, yes, well, we'll count that, but it's not going to be enough in our overall determination, unless you have other things that are much stronger, like other criteria that you're meeting, that's stronger. So I hope that's clear.
Yep. Yeah, absolutely. Thank you so much.
Okay, thank you.
All right, we have another question in the chat. Nateen, Nora, if you want to ask, or I can just read off the message. Okay, so her example is, if I open up a restaurant and I graduate in accounting, can I be the accountant of the restaurant and still apply to H-1B?
That's potentially possible. So yes, that an accountant would be considered a specialty occupation. So if you can show, now keep in mind they will look at it, because we even for employers where you don't own the company. So we've had instances where a restaurant like that example is applying for an accountant. They have to show, why do I need an accountant? Is that something typically that a restaurant needs to have, rather than using an outside accountant, which many companies, businesses do? Why do I need to have an in-house accountant? So you're going to have to really show that need for having an in-house accountant for a restaurant, because it's not typical. Of course, if you're working at an accounting firm, yeah, that's going to be pretty straightforward. But in situations where it's not typical for in-house accountants to work, then you're going to have to show more. So that would be the case whether you own it or someone else owns that restaurant in itself. Now, if you wanted to start a accounting business, yes, you could probably easily get that H-1B approval.
Kind of a follow-up as you were talking about that. So if a person starts an accounting firm, but it's like an accounting consulting firm where they contract out to other companies who need accounting services, would that still be considered as a valid business model, and potentially they could still apply for the H-1B?
Yes, I would think so. I mean, it's not uncommon. It is a valid business model where your customers are other accounting firms, for example, but their skill set that's needed does, relate to your specialty occupation. It does relate to your degree background. So, but it's a good question, because part of the H-1B requirement, especially for self-employed, is that you do show that there is a legitimate business and there is potential for the company to have business. So if you have contracts in particular with other accounting firms that are wanting to use your services for whatever reason, as overflow, as attorneys, we do the same thing. We hire contract attorneys and things like that. So it's not unusual. So if that's the business model and you can show that you have the potential for business, then it should work.
Right. We have a question from Sneha.
Hi, yes. My question is, on STEM OPT, do we have to work a W-2 job, or a 1099 would also work?
Generally, it's usually a W-2 job as an employee.
Okay.
Yeah, I mean, it could be W-2. Well, no, it probably would have to be W-2, because the requirement is for the employer to be E-verified. And so only employers only E-verify their employees, not their contractors there. So you would need to be W-2.
Okay, got it. Thank you.
Mhm.
We have a question from one of our staff members, Michelle. She asks, is there any advantage to starting a business that produces products versus a service?
Yeah, that's a good question. I can't think of any advantage as far as the visa is concerned. We've seen both of those, situations. It depends on the type of visa. Again, for H-1B, it's more focused on what is the position, the employment position that's being, sponsored. And so we have to make sure that it makes sense with it. If it's a product business, it makes sense that the individual who's being sponsored is working in their field of expertise. For other businesses like an E2 or an O1s, it would not make any difference, as long as you can show. For O1, you have to show, of course, that you will you have that national recognition, so you will still be using your skills or your expertise in that business, whether it's a product business or a service business. And then for an E2 visa, yeah, they have approved service businesses as well as product businesses. So I don't see any difference there.
Right. I'm going to try and unpack a big can of worms now. You had mentioned the cap exempt employment that does not go through the lottery system. Can you define for us, maybe in a short way, what kind of startups could qualify for a cap exempt status?
Okay, so for startups, it's probably going to be pretty difficult to qualify for cap exempt unless, well, there's different types of cap exempt. So there's cap exempt like universities, UTD is cap exempt, right? Nonprofits that have teaching affiliation. So a nonprofit, if you're a nonprofit startup and you actually help with students, like you provide opportunities for students to train at your facility, or you provide some kind of educational component to students at a university or a college, then you can potentially be cap exempt. But if you're a for-profit company, then in order to be cap exempt, you would have to show that that the employee, the H-1B employee, will be working at a cap exempt facility like UTD. So for example, if you're going to be for profit, but you're operating at UTD, for example, and you're having some collaboration with UTD, and that particular employee will be collaborating and collaborating with the university as well as with students at the university, having some kind of teaching component to it. Not necessarily that they have to be a professor or anything like that, but the students are going to be able to collaborate with your company and be able to learn, or be part of, pretty much learn from whatever collaboration they're having as part of their studies as well. So those would be the ways that you could actually be considered cap exempt, either being a nonprofit with that kind of affiliation with a university, or being a for-profit, but having at least 50% of the time that H-1B employee will be working at a university or even on behalf of a university situation there. Now, there's also what we call the concurrent H-1B option. It's not for everybody, but it really is more focused on that H-1B employee. So when we talked about having more than one H-1B, if you are working for a cap exempt employer, let's say you work for the university or some other cap exempt employer, whether it's part-time or full-time, you can have a concurrent H-1B that is not considered cap exempt, where it may be your startup company. So your startup company is for profit. If you didn't have that cap exempt employment, you would have to go through the H-1B lottery. But because you have cap exempt employment, you can now have a concurrent H-1B with a private or for-profit organization. Again, as long as the occupation that you're doing is within the specialty occupation there. So some people have done that. There's even, I think, a couple of companies out there that offer some sort of arrangement where you can get a cap exempt H-1.
Is everyone still here?
What's that?
Yes.
Sorry, and your video blocked out
Oh,
as soon as you started talking about the companies that arrange for cap exempt.
Oh, okay. Were you able to hear it though?
It was completely frozen for me, but if everyone else heard it, it's probably on the recording too.
I did not hear it.
Okay. So, that was when I was discussing the cap exempt concurrent H-1B, correct?
Right.
Okay. So I'll
It
start
was
over.
into the topic, just at that point where you're
Yeah,
talking about how some companies will arrange for cap exempt H-1Bs for a fee or
yes,
price, and then you
right.
can work on your startup alongside.
Exactly. Yeah. So basically, you would have a contract with that company. They have arrangements with certain universities. They actually, from what I understand, the universities can be remote work with the universities. So, and it's very limited, maybe 3 or 4 hours a week, or could be more, but very minimal amount of work to be done with those universities. So, but that gives you the cap exempt H-1B, which now allows you to work either on your own startup or for another for-profit organization company that can sponsor your H-1B full-time or even part-time, doesn't matter, but you can have another H-1B without having to go through the cap.
Right. Thank you. Briefly going back to another question on the O1 and EB1, is there any minimum number of papers published in the relevant field which would significantly boost the chances of getting the visa or the green card application?
Yes, so unfortunately, they don't give us that clear cut of a definition for it or criteria. So there is not really any minimum. We've worked with people with as little as 5 and some with, hundreds of papers. So it ranges. Of course, having one, I would say, would not be enough. You do need to have multiple papers written, and it depends also on your field because some fields, you don't really, it's not really a thing for people to write papers. Some of the more hard science fields or things like that, where you're always doing research and publishing papers, they're going to have a higher expectation of more papers there than in a situation like we worked with some people in technology where it's not, they're more in the industry, they're not necessarily researchers, but they've done a few papers, and so that has held some weight because it's unusual for people in industry to have papers, because what you're doing is making a comparison of yourself to other people very specifically in your field. So I can't really say there's a minimum number. It's really a case by case basis. When we evaluate them, we look at the overall field, what's specific. Maybe there's been some, we can't just say computer science in general. We'll say, maybe you have a very more specific expertise, and we'll talk about how you're, well known in that specific area. So it just really depends on each person's background, but I can't say there's a minimum number. I could just say more than one at this point.
Right. Thank you. The next question asks, given H-1B is the traditional sponsored visa we all hear about, what happens if an employer terminates an employee before the visa period is over? What are the options then?
Correct. So if your employment is terminated, or even if you decide to terminate, the government does provide currently a 60-day grace, what we call grace period, where you can remain in the US and find another position and have the new employer, or if you start up your own company, you apply for an H-1B, and you would want to try to do that before that 60 days. So if you were terminated on June 10th, then by August 10th, you would need to have found a position and have that H-1B petition by the new employer filed before August 10th. Now, it could happen afterwards, but what happens then if you apply afterwards, then the government can say, yes, we can approve you for H-1B, but you will have to leave. You will have to go to the embassy, U.S. embassy in your home country, and apply for a visa and come back in order to activate that H-1B. So if you want to avoid having to have that travel requirement and visa requirement, then you need to try to get that new H-1B filed before 60 days has expired since your termination date.
Quick follow-up on that. If it's after the 60-day window, it's at the discretion of the government whether to give you the extension, but there's no lottery. If they say it's okay, you just have to go back, somehow get the date at the embassy to get a stamping, but you're not in the 20% lottery pick anymore.
Correct. Right. Once if you have already been counted in the lottery, and you're still in a 6-year time frame for that lottery, from the time you got it, if you still have time left, then yes, you don't have to start over in a new lottery.
Right. Sneha asks, if you own a company or partially and are on STEM OPT, are you required to issue a W-2 to yourself?
So if I'm understanding, you are working for that company, the company, your own company, and working for another company. Could you clarify
No,
that? No. Okay.
no.
So
It was just a follow-up on the previous question of working on W-2 on the STEM OPT.
mhm.
So it was just a question of if you own your own company, would you need to issue yourself that W-2 in order to keep working within that company you started?
Right. So assuming that, you have someone that can provide the training and everything is in place for the STEM OPT requirements, yes, you still, even as an owner, you are an employee as well.
Right.
So you have to be treated as an employee, regardless of your ownership interest.
Okay. So we would need to get all that document that makes
W-2 and
it
all of that. Mhm.
W-2. Okay. Thank you.
All right. Any other questions? We have about 8 minutes to go.
I have a question.
Yep.
This isn't really a specific question, it's kind of open-ended, but I imagine, your firm has really dealt with a lot of cases in the past, given it's been operating for so long. Um, and really, I mean, I'm sure I don't only speak for myself here, but I personally feel very naive when I'm thinking of immigration and navigating all the paperwork and case structures in this country. But where have you seen most success in, someone trying to, I guess, pursue self-sponsorship, or whether that's concurrent, cap exempt, or really any institution? Where have you seen where there's high likelihood of success?
So what you mean by that is actually getting the visa or eventually getting permanent status, so kind of
Correct.
if you getting permanent status
Yeah,
by
when we think of the
self-employment.
long term, when we
Yeah,
think of the long term and not just short term,
right. Yeah, so definitely we have worked with a lot of people who have applied for their long-term permanent status through the EB-1A category. So I mean, what we've seen though is people, if you usually some people will come to us and they'll say, I want to try for EB-1A, but what we have to do is to look at, do you have, the necessary career accomplishments to meet that? And so being a little bit patient and trying to work towards that by doing those different things like writing the papers or speaking at conferences, or being on peer review. Like it will take a couple of years to do that, to get to that point where you can apply on your own. But we have had many people who have taken that time to do that in different occupations, and they've been successful in getting EB-1A and getting that permanent status without being tied, to a particular employer, because that's one of the big advantages to EB-1A is that it is self-petitioned. It is, of course, based on your field of expertise, but it's not based on any particular employment or working with a particular company. And it's also a lot faster for some, for most people, it's much faster to get that. So I would say if you were in the beginning stages, like now, coming out of school and everything, and thinking of how can you most quickly get a green card, you want to look at that EB-1 category and try to figure out, what things you can do to get on that path and eventually be able to get that green card on your own.
All right, thank you so much.
Vishal asks if you could briefly talk about the L1 visas.
Sure. So L1 visa is what we call the multinational transfer visa. So this is where either you as a top level manager or as someone who has special expertise with a multinational company. And when I say multinational, it doesn't have to be one of the huge, companies that we all hear about. A multinational simply means that there's a foreign operations and a U.S. operations. So in order to show that to qualify for L1, you would have to show that you have worked for the foreign operations for at least 1 year before your entry into the U.S. So before you came in as a student, if you worked for 1 year for a company, in whatever country for a year, and even though there's been somewhat of a break, maybe in 3 years, you are trying to now get an L1 visa with their U.S. operations, it's possible that you could apply for an L1 as opposed to H-1B or something else, or another type of visa. With the L1, there is no limit. There's no limit to the number of visas available. But again, it's very, very specific that you have to show that you've worked for a company, foreign operations, and now qualify to work for their U.S. operations. And by qualify, either you have to be a high-level manager for the U.S. operations, or you're bringing some kind of special knowledge from the foreign operations to the U.S. operations here.
Thank you. Maybe we have 4 minutes, so Charlotte has another question. Yes.
Yeah, and thank you for the answer. Just a quick follow-up on that. So
Sure.
when you say that it has to be a very specific skill set, and considering how AI is like now this like emerging field, would like AI careers be considered, or is there like a list of specific skill sets that people are looking at?
Oh, so for L1, it's not necessarily a specific skill set. What they actually call it special knowledge. So what they're saying is that it could be, for example, the fact that you worked for the company, the foreign operations, and you have very I guess special knowledge, or you have the technical know-how related to their operations, that they want to bring someone over who already knows how their company operates, knows how the processes for their products or services are done. And so you have that special expertise. It could be an AI, it can be anything. It depends on the product or the services that the company is providing here.
Okay, yeah, perfect. Thank you.
We have a follow-up on the L1 visa information from Mary Rose. She asks, can you tell us the process for changing the status from F1 to L1? Should it be done in my home country, or can it be done here?
Okay, sure. So if you meet the qualifications and the company meets the qualifications and everything there, you can be applied for here. You can do a change of status from F1 to L1, as long as you are in status on you have maintained F1 status. So you have to be sure that you're within the timeline required for that. But you don't have to go to if you are in status, in F1 status, and everything is valid there, you can do a change of status to L1. So the company that you're going to work for has to submit their application. It's called an I-129 application, and they provide all the information to prove they're multinational, prove that your occupation is either a high-level manager or special knowledge. Also prove that you did work for their foreign operations within the time frame required. So if they provide all of that, then they can get, and if it's approved, then you would just get a new I-94 that says your status is, as of whatever date, is now L1, and then you'd start working for the company here.
All right. Thank you. We have 1 minute left. Do you want to take one more question, or we can
Sure,
wrap up?
I can take
here?
one more if anybody has one. Sure.
I had one on the EB2 national interest waiver.
Okay. So for the EB2 national interest waiver, so that is another application, one of the few that you can apply for without having an employer sponsorship. And it can, we often do see people who are self-employed or wanting to, qualify based on their own company. So it's, like it says, national interest waiver. So it means that you have to show that the work that you will do is in the U.S. national interests, and in pretty much any area. It's not specific to any particular occupation, but generally looking at, are you going to somehow help improve of the industry, education, for example, or technology. There's some improvement in technology. Different healthcare. There's all different aspects. Oil and gas. It can be pretty much any industry, but you have to show that the projects or the things that you're going to be doing will be a substantial improvement of national importance. So it can't be that you're going to be making money for your own company or benefiting your own company. It's got to be sort of I say a game changer in the industry in some way. There's something that you're bringing to the table that the U.S. Would want to see. Now, again, it's not the U.S. government, doesn't have to be the government, although if you have government support, it's a much stronger application. But it just has to be that there's some interest that that the U.S. has, and you're going to help to meet that interest in some way. The only thing is it is an EB2 category, so there is right now a backlog for EB2. So whether you're going through a PERM employer sponsorship or an EB2 national interest waiver, it's the same category. So those of you who are from India or born in India, it's going to be the same time frame as if you were sponsored by an employer in the EB2 category. And the other requirement for the EB2 national interest waiver is that you have to have a master's degree or higher, or a bachelor's plus 5 years, which is considered 5 years of experience, which is considered equivalent to a master's degree.
Right.
But there's more to it, but that's about all I can answer in this time frame.
Yes, of course. If you have time for one more question on the
Sure.
L1, we have Liberty who's asking, what is the time limit to get an L1? Because she or he changed status from L1 and would like to return to the same company after school.
Yeah, so I think there's someone who answered that pretty well. It's like you have to it's in the past 3 years that you've been an employee. So if you've only been in school for 2 years since you came into the country on your F1 status, then you might be eligible to do that. But if it's been 4 years or so, then you probably will not be eligible for L1 again, unless you go back and work for that company another year or so. Go back to the foreign operations. Mm-hmm.
All right. Thank you so much for taking the extra time as well.
Sure.
We really appreciate your expertise and giving us
You're
your time
welcome.
to come help answer all these questions.
Thank you.
But that's all we have for today's session. Thank you,
Yeah.
everyone, for connecting. And if you'd like more help, we'll be happy to share Anne's law firm's contact information. You can find her on LinkedIn as well, in case you want to get legal assistance with some of these processes.
Yes. Thank you so much. Well, I enjoyed speaking with all of you. So, and good luck to everyone. Thank you.
Thank you.